Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. In today's class, I will discuss about most important topic, that is offense of cheating versus personal dispute. Sometimes it is seen that the personal dispute or commercial dispute or civil dispute is entirely projected by the concerned complainant as offense of cheating. The concerned police lost the FIR even though the offense is basically a civil dispute. Entirely we are harassed, humiliated, and pressure is mounted on us to refund the amount. And under pressure of being arrested, we inter alia pay the amount. So basically, the police is not having any power to resolve the civil dispute because the civil disputes are the absolute jurisdiction of the concerned court. The concerned complainant has to approach to the concerned civil court, but despite of that, he adopted the illegal method so that the illegal recoveries could be done. So if it is going to be happened in your case, what steps are required to be followed, I am going to specify. So basically, we have to emphasize on the basic cause, that is cheating. What is cheating? So cheating could be defined as, please be noted, a criminal offense in which a person knowingly makes a false statement to another person to induce him to part with any property, to do or to omit to do a thing which he would not do or would do if not so deceived. And thereby the concerned person, means the victim, suffered the loss in his body or mind or reputation or property. In that scenario, the offense of cheating will be constituted, which is part and parcel of section 318 subclause 4 of BNS. But in the routine way, the process could not be brought into motion. So whenever the concerned complainant submit the report to the concerned police with a view to take action against you, at the inception the police will call you to resolve dispute. If dispute is not resolved in that scenario, they will proceed to lodge the FIR. So basically, whenever a report is submitted, try to submit your reply on the report with evidences, because in case they are going to register the FIR without considering your case, in that scenario you may chalk out the case for the unfair proceeding, and even you may get stay on the proceeding in the easy way from the Honorable High Court, because if you specified that the dispute is not the crime, it is basically a commercial dispute or a civil dispute, in that scenario you may directly chalk out a clock on the existence of the concerned FIR. As we know that the criminal law cannot be set into motion in the routine way. The justifications must be on record, and apart from that, the ingredient of the offense must be on record. If the ingredients are absent, the dispute is civil. In addition to this, the concerned parties are having the commercial engagements. In that scenario, the FIR as per offense of cheating could not be registered. So basically, I'm going to specify you the practical way also, so that if the FIR is lost or if there is any report, you may submit your representation on the facts and could specify to the concerned authority that the report or the concerned FIR is nothing but abuse of process. In that way, you may get protection to your rights from being prejudiced. So the core point is that you have to emphasize that the dispute is civil dispute or a commercial dispute or a personal dispute. No crime has been committed by you, and even the statement is not false. You have not acted fraudulently or dishonestly. No wrongful loss has been caused to the concerned complainant, and no wrongful gain has been caused to the concerned accused. In this way, we may specify our stand before the concerned police. In addition to this, if after lodging of FIR, the concerned IO is willing to arrest you, in that scenario, you may move either for anticipatory bail as per section 482 of BNSS, or you may go for questioning. Because we must understand that the maximum punishment given for the offense of cheating is 7-year imprisonment. So, as per law, that is 41A of CRPC or section 35 subclause 3 of BNSS, if the offense is punishable up to 7 years, no automatic arrest could be done. The concerned police is bound to issue notice as per section 41A of CRPC or as per section 35 subclause 3 of BNSS if the notice is not issued. In that scenario, while challenging the impugned proceeding in the questioning jurisdiction or while moving for the anticipatory bail, you may specify all these things and could pinpoint your case. because in the questioning jurisdiction and while moving for the anticipatory bail, you have to specify which provision of law is going to be violated by the virtue of which your liberty is about to be compromised. If your facts, your reply are not specified, they are not pinpoint, you are not pinpoint on the legal point, in that scenario you could not be succeeded, because these are the special offenses you are supposed to be pinpoint on your case. Apart from that, as a defense, you may submit WhatsApp communication, phone call recording, email communication to show that the dispute is civil or commercial or personal dispute. You never made any false statement, and apart from that, you never induced the concerned complainant to part with money in the illegal way. In addition to this, you may show your financial position, and you may show that you are having more dominant financial position as compared to complainant, and that's why you are not having any ill intent to get the money in the illegal way. And the said document could be the good defense point. In addition to this, you have to specify that you are not having the illegal motive. In addition to this, there is no inducement on your part, and you never averted any false statement. Regarding this, you are supposed to give the proper explanation to the facts averted in the report or in the FIR with specific evidences and averment. So I request all of you to submit your proper reply to the concerned report or to the concerned FIR, that is called representation. So in case it is not going to be considered, you may chalk out the case for unfair proceeding and could be succeeded even at the stage of discharge or trial before the concerned court. So these protocols are required to be followed so that we could be succeeded. In addition to this, I am going to specify you two important judgment of Honorable Supreme Court that is quite important on subject. Judgment number 1, 1998, Volume 8, SCC, page number 245. Mere deception by itself would not constitute cheating. Judgment number 2, citation is 2000, Volume 4, SCC, page number 168. To constitute cheating, two elements must be on record: dishonestly induced to deliver property. In addition to this, the deceiving with such intent to cause a person so deceived to do or omit to do a thing which he would not do or do if not so deceived. Inter alia, the same resulted in loss of body or mind or reputation or property. The offense of cheating will be constituted. So, in the routine way, on mere facts of civil dispute or commercial dispute or personal dispute, the cheating could not be constituted. So, I specify you the important information about the offense of cheating, both in the theoretical perspective as well as in the practical perspective, what to do if you are falsely implicated in such cases. See you in the next video. Till then, Jai Hind, Jai Bharat.